Easy, Lord.
And in respect of Part 2 hearing list, item numbers 12 and 13, I'm the amicus in item number 13. I have not been supplied a copy of the paper book. May I be permitted to make a copy from the file itself?
No, they'll give you. Get a copy given to him. Item number 13.
1-3, part 2.
All right.
I'm of that.
For orders, item.
May it please your lordship, my lord, we have filed our rejoinder today. I filed a rejoinder today because
You are for the petitioner.
petitioner, I am for that.
What is there in this case?
My lord, the issue is, my lord, we are the villagers over that particular village. The village grazing land was, for trade purpose, was directly settled with that person. And within 3 years, he has sold those land by taking those land in a less premium amount. He has sold those land in a higher price to other person within 3 years. And my lord, when their land policy prevalent during that time has prohibited de-reservation.
Where is the prohibition?
My lord, I take your lordship, my lord, to the review petition or the provision, my lord. Provision is this, my lord. In the rejoinder, I specifically stated that also, my lord. This is, my lord. This is the policy. Here land and from the left side, my lord, last Vizier land. I'm sorry, my lord, I have not been able to give 2 books.
Yes, sir. I am.
Sorry, my lord, I am. And my lord, the document through which it has been given, in their affidavit, they have
provision in land policy.
1989, my lord.
Clause number?
That Vizier land, my lord.
6.1.
No, you are saying that within 3 years, the land allotted to
Not only that, my lord, we have 3 counts.
First, let's deal one by one.
My lord.
Your first ground is within 3 years, land cannot be further transferred.
My lord,
That your first
that is for if the land is for special cultivation, within 3 years it cannot be done. If it is for special cultivation,
the provision?
my lord, there, my lord, if I can show it, my lord. And but in my lord, in any purpose, land cannot be settled for trade purpose, for any way.
Where is that? Please flag it. Who is appearing for the state here?
In Bordoloi, my lord.
But he is not to be seen.
It is there 5.4. It is stated, my lord, can I read it slowly? The allottee must utilize the land within 3 years of the allotment for special cultivation, failing which the allotment shall be cancelled.
So that, according to you, means he cannot transfer it within 3 years.
My lord, if he, and it is, first of all, another policy is there, my lord, that if a particular land which cannot be settled with somebody, immediately he has to be evicted from that land. Because Vizier land cannot be de-reserved, my lord. The policy.
So, Mr. Roy Chaudhary, please
My lord.
understand the query.
My lord.
You are seeking a review. We are not going to decide the PIL.
No, my lord. The 3 counts I am doing.
Review will be maintainable, as you know.
On the error on the apparent.
Yes. So what is the error apparent on the face
My
of
lord,
the
because
report?
there are 3 counts available, which was not considered by that.
Which are the 3 grounds?
First of all, my lord, Vizier land cannot be settled and cannot be de-reserved. And that too only for trade purpose. For personal trade purpose, it cannot be settled for Vizier land. That was the first contention that I want to place it. Next, my lord, if at all it can be settled for special cultivation, it has to be utilized for that purpose. Before 3 years, he cannot sell it. Impliedly, its contention is this, my lord. If it is for 3 years, he has not utilized it, it gets cancelled. And the land policy also says, my lord, encroachers and evictions, encroachers on government land, including reserved land, and land acquired under various land ceiling acts who are not eligible to get settlement of land as per land policy shall be evicted expeditiously.
according to you, these points were not dealt with by the learned judge. That means if you are correct, the judgment is erroneous, the
My-
order is erroneous,
My lord,
that cannot be corrected in a review. You may be correct, but on the face of the record, this is not an error apparent on the face of the record. These are matters of interpretation. The interpretation, what you are suggesting may be the correct approach, may not be the correct approach, but the review court cannot go into that. For
Not-
review, you have to show that something which was X has been treated as Y on the face of the record.
only on the face of the record, if your lordship permits me,
No,
my lord.
Mr. Rochester, I'm so sorry.
My lord, only that document, my lord, at page
What
25.
you are saying is, this is your interpretation, your submission.
No, my lord, at page 25, their affidavit is there, my lord. But they have stated there was that it is only grazing land which was de-reserved. And it was settled for trade purpose. It is their document.
Correct. So the learned division bench did not consider it.
No, my lord.
That is erroneous order then. We can't rehear the matter and take a different view.
So, my lord, your lordship will permit me.
According to the learned division bench,
My lord.
your submissions were found to be incorrect.
No, my lord, court held, the division bench held, the learned counsel could not place it before the court, that was not there. It was there to the learned
Even
counsel.
now you are unable to place it. What you are saying is a matter of interpretation.
My lord, here it says that it will not be reserved. VGL land will not be de-reserved. That's it, my lord. If I read it slowly, my lord, the land under VGR and PGR will not further decrease by way of de-reservation and allotment.
So have you challenged the order of reservation?
My lord, they have filed
No,
through an
your
affidavit.
No.
They have filed through an affidavit, and we are
Mr.
saying,
Rochaudhary, you are a seasoned
my
experienced.
lord, your lordship may dispose of with a direction that I may be allowed to challenge this by way of writ
Of
petition.
course you are.
My lord, your lordship may dispose of in that kind of way, not by way of dismissal, but your lordship may give me a permission that to challenge this through way of a writ petition.
Lordship, they have filed the affidavit in reply today. They will be filing. I have just received the copy.
No,
just
but
now.
we'll, as you said, we'll close it. We'll say that there is no error apparent on the face of the record. However,
Yes,
if
your
the
lordship.
petitioners are aggrieved by the order of allotment of land in
Ah.
favor of the respondent number 5,
Yes.
is
My
it?
lord.
Yes.
It will be open for them to challenge it by
Yes,
filing
in-
appropriate.
In my,
We'll
in
say-
the affidavit in opposition filed by the Revenue Department, your lordship, it is clearly stated that the process of allotment were all according to the law, as per the law.
That's
Nothing
all
was-
right.
Yes,
That
yeah.
aspect we are not deciding here.
Yes, sir.
He will challenge it as and when he does it. You take your stand.
Yes.
My lord, your lordship will not write dismiss, but dispose of.
All right.
with it.
If that
Oh,
makes you happy.
My
all right.
my lord,
But there is no ground for review in this case.
Yes.
my lord.
Heard Mr. P.K. Rochaudhary, learned counsel appearing for the review petitioner. Also heard Ms. N. Bordolo, learned.
And your lordship, N. N.
Yes, that's what I
Yes.
said. N. Bordolo. What did you hear?
M. M for
N.
Mumbai.
M question. Some problem with the acoustics.
Yes,
Looks like. Bordolo, learned standing counsel revenue department appearing for the official respondent. None has appeared for the remaining respondents. Full stop. By filing this petition, the petitioners in PIL number 77/2021 has sought review/recall of the order dated 15/12/2021 passed by the division bench, disposing of the PIL on the ground that the same was devoid of any merit. Full stop. Mr. Rochaudhary has invited the attention of this court to the Assam land policy of 1989.
89
More particularly clause.
clause, my lord, 6.1, 6.1.
6.1 to submit that VGR land cannot be de-reserved, nor can it be settled for trade purposes. And to that extent, the allotment made in favor of the respondent number 5 was illegal. First off, Mr. Rochaudhary has, however, clearly submitted that the order of allotment made in favor of the respondent number 5 is not under challenge in the PIL. Full stop. Ms. Bordolo, learned standing counsel revenue, on the other hand, submits that the department has taken a stand in the affidavit filed in this case that the process of settlement of the land in favor of the respondent number 5 has been is strictly in accordance with the provisions of law. And
After
therefore,
realizing the full premium.
after realizing the full premium, and therefore there is no scope for interfering with the order of settlement. Be that as it may, after hearing the submissions advanced at the bar, this court is the opinion that there is no error apparent on the face of the record, nor any other sufficient ground for this court to review the order dated 15/12/2021 passed by this court, full stop. If the petitioners are aggrieved by the order of settlement issued in favor of the respondent number 5, then the same would be a separate cause of action which can be agitated in an appropriate proceeding. Therefore, by granting liberty to the petitioners to pursue appropriate legal remedy as may be permissible under the law without prejudice to their rights and interest in the matter, this review petition stands disposed of.
I'm obliged, Your Lordship.
Obliged.
May I please, your lordship? And can this matter be posted after 6/12, my lord? Because the CGM has already issued a notice to the aggrieved person, my lord, because her whereabout is not known. So we have filed a petition in the CGM for depositing the maintenance. The CGM has already issued a notice and the date was fixed on 16/12. So let that notice become whether she is there or not, because according to our information, she is in America. So that notice will reveal that, my lord. Can it be posted after 16/12?
So these steps were taken as per order dated 16/10.
Yes, my lord.
2023. All right, you take down Mr. K. Bhattacharya, learned counsel appearing for the appellant submits that in terms of the order dated 16/10/2023 passed by this court, his client has taken steps for producing the relevant documents, including the proof of payment.
Item 3.
May it please your lordship. Lordship, may I previous order dated 4/10/2023 passed by this honorable court. This matter was already fixed for hearing today, but inadvertently, lordship, it is listed in orders column. So may I please next week any hearing date may be fixed?
No.
Mr. A. Ahmed, learned counsel for the appellants, as well as Ms. B. Bhuya, learned APP Assam, and Mr. M. Hussain appearing for the respondent number 2, learned counsel appearing for the respondent number 2, have submitted in tandem that this matter was earlier fixed for final hearing, and therefore the appeal has been wrongly listed for orders today. In view of the submission made at the bar, registry to list the appeal for final hearing as a fixed item after 2 weeks.
Obliged.
Item 4. Item 4.
Where is Mr. Nath? S. Nath? The contempt proceeding has been initiated. We'll pass it over for the time being.
For hearing item 5. 5 and 6.
Lordship, this matter was heard by another bench, and this matter was fixed for reply of Ms. Ed Jahan. Will Lordship may kindly have a look at the order dated 17/8/2023.
Release, my lord.
It is really sir.
Release, not
Could
party.
you come in, Lordship?
Release correct.
Ms. Bhuya, which order you are? referring to?
17/8/2023. You know? Then the matter came up on 11/10
11:10 or 10:10?
or 10/10. On the prayer of Mr. D. Talogdar. This matter is fixed today.
So it appears to be a parted matter.
No, my lord, it was heard, my lord. Then his lordship, Mr. Zothankama, had to leave for Aizawl, my lord. It was,
Like, who order sheet
but
of-
It's a
no,
parted matter. Let it go before the bench. Don't mind, where is the order releasing it from parted?
it was not made parted, my lord. It was fixed
Oh,
for,
the meaning is that if one side is hard, what is the meaning of parted?
my lord. Yes, my lord. It was specifically not made because on last occasion, my lord, his lordship had made it because he was not there in Guwahati, my lord. He had said listed after 2 weeks.
I am not aware of it, Your Lordship, because Miss Jahan, she dealt with the matter.
Go by the-
Well, Lanet Senior was also there.
Order sheet doesn't say so.
You are not ready with the matter.
No, Lordship, I was not there on the last occasion
Hmm.
because Miss Jahan, she dealt with the matter.
All right, let it go for the appropriate bench. Mr. N. Mahajan, I counsel for the appellant. You are in which case? Item 5.
Item number 5, my lord.
And who is in? Also heard Mr. H. Nath, Learned Counsel for appellant in item 6. Is
Amjad today.
M. Bhuya, B. Bhuya, learned senior advocate and additional PP Assam has appeared for the state in both these appeals. It is pointed out at the bar that these appeals were extensively heard by a coordinate bench. And by order dated, what is the order?
17/8.
17/8/2023. The appeal was fixed for further hearing for reply of the learned APP. Full stop. If that be so, although the expression within course parted is not reflected in the order, it is apparent from the records that these appeals are parted before a coordinate bench. Ms. Bhuya, learned APP Assam also submits that since the brief was handled by Ms. S. Jahan, learned APP Assam, she is not in a position to make further submission in the matter today. Is that correct?
No, about releasing for Pata, that is not, I'm not aware of it. But I can do it if they starts the
Ms.
matter.
Bhuya submits that since the matter is handled by, the brief is handled by Ms. S. Jahan and it is a parted matter, registry be directed to list the case before the appropriate bench. Taking note of the submission of learned counsel for both the sides, these appeals are directed to be listed before the appropriate bench.
Obliged, my lord.
Item 7.
Lordship, I was dealing with another Amjad. I'm sorry, I didn't see the case number. It's a POXO matter and I'm ready with it, but it will- 34 May. একটু মনে আছে না নাকি? হ্যাঁ। না লাগে। আবার মই একটু ready আছে। Note আছে।
Lordship, here in this case, before starting the case, Lordship, just I'm pointing out to your Lordship that the appellant number 1, Amjad Ali, he already died. So against him, the case will be abated, Lordship. He was released on bail on medical ground and subsequently he died. I have the death certificate also.
So there are 5 other appellants. This is a consolidated appeal by all of them.
Lordship,
This is a consolidated appeal. by all-
Lordship.
We'll hear the matter,
I have not prepared it, but my note is there in the file.
but making parted will be difficult because these benches, I don't know whether it will be there next week or not.
Both কেটা
You'll
witness.
have to finish.
There are 17 witnesses. সময়
17
লাগিব নাকি?
17 witnesses are there.
I leave it to your lordships.
You can hear it. finish it.
Here in this case, Lordship, FIR, your Lordship will find page 4.
What is this? Is tagged together. Yes.
Although Lordship, my instruction is not relevant in criminal appeal, but what I find, Lordship, as per my instruction, and there are some material in the Lordship paper from the record, Lordship, that supports that instruction. Therefore, I am just placing for your Lordship the facts what happened here. In the night of alleged incident, Lordship, the two persons were residing in a river near a river by constructing a house, Lordship. The river was in the near the border of Bangladesh, Lordship. They were trading in cattle business. They were other business they were doing with Bangladeshi peoples. They have some enmity with them. At night, someone came and killed them. And subsequently in the morning, the two persons were found dead by the relatives. And as there was some enmity with the appellant, Lordship, thereafter these persons were implicated in the present case. From the medical report, your Lordship will also find that it supports my case, Lordship. Some unknown persons killed. Subsequently, these persons
So
were
it is a case
implicated.
of circumstantial evidence.
No, they projected themselves as eyewitness.
Eyewitnesses.
Eyewitness. They projected themselves as eyewitness, but your Lordship will find there are
Who are the eyewitnesses?
9, 10, and 11.
No, according to my note, it's like PW5, PW4 is injured eyewitness, PW5, PW6, PW8, PW9, PW10, PW11.
PW 4, 5,
4, 5, 6,
8, 9, 10, 11.
8, 9, 10, 11.
And trial court relied on 9, 10, 11.
all right. Let us see what is there. You can start.
FIR, your Lordship will find page 4.
Page 4.
4.
Yes.
FIR was lodged in the year 11th October 97. Lodged by Usman Ali. He was examined as PW4. Humble submission is that we, the brothers, have the right and possession over the plot of land described in schedule below. My younger brother, Rahman Ali, had been residing in the said land by erecting a house therein. Around 6-7 a.m. today, the below mentioned accused persons by forming an unlawful assembly armed with deadly weapons, such as sharp spears, lathis, pebbles, etc., launched an attack causing Rahman Ali's instantaneous death. So here, Lordship may kindly note that Rahman Ali's instantaneous death. But medical report says otherwise. Therefore, I have pointed out before Lordship that they might have been killed by unknown person at night itself. Rahman Ali's instantaneous death and my son Sukur Ali's grievous injury. On being referred by the doctor of Gajarikandi PSC, Sukur Ali was sent to Dhubri Civil Hospital for treatment. The witnesses will prove the veracity of the incident. The consequence of the said attack, the below mentioned persons to sustain injuries, grievous injuries. 3 of injured Anwar's teeth got broken as a result of. It is therefore paid that 4 persons are named as injured. Sukur Ali, who subsequently died, Lordship. Anwar Ali, he was examined as PW11. Ainal Haq, he was examined as PW9. And Nur Islam, he was examined as PW10. Here, your Lordship will find 15 persons were named as accused in the FIR. Out of them, thereafter 2 persons were included, Kubad Ali and Sattar Ali, in the charge sheet. So total 16 against 16 persons, FIR was charge sheet was submitted. And during trial, after trial, Lordship, 7 persons were acquitted on the basis of the evidence on record, and 6 persons were convicted. 6 persons filed the present appeal. Out of them, Amjad Ali died, Lordship. So 5 persons before your Lordship.
All right. Now, charge was framed under which sections?
302, Lordship, and
Let us see.
149.
And 149.
149,
These 2 provisions.
Lord.
302 and 149.
Lordship.
Okay, now let us see the findings of the trial court.
Findings of the trial court, your lordship will find. Judgment, lordship, 480 page, starts from 480.
No, where is the relevant part?
And lordship. And appreciation of evidence, your lordship will find 496, paragraph 40 of the judgment.
Yes.
Paragraph 40, I am reading, lordship. In this case, all the vital eyewitnesses 4, 5, 6, 8, 9, 10, and 11 are relative of the deceased. Eyewitness account of PW 4, 5, 6, 8, and 8. As per evidence of these PWs on the relevant date and at the relevant time, the accused persons, namely Amjad, Haidar, Motiar, Nur Bakhtar, Joel Haq, Nur Islam, Shamsul, Rezak, Bakhtar, Kobat, Sattar, Monser, Sofial, and others armed with deadly weapons came to the PO. So out of them, some are acquitted, lordship. With deadly weapons come to the PO in a body and assaulted Rahman Ali and Shukur Ali. It is in the evidence of PWs that the above named accused persons armed with falas, spears, sulpis, sharp pointed instrument made of iron, lathi, etc. These PWs have also categorically stated that as a result of assault, Rahman Ali died on the spot and Shukur Ali died on his way to hospital. Evidence of injured witness 9, 10, 11. These witnesses have stated that on hearing Halla in the premise of deceased Rahman Ali and Shukur Ali, they came to the PO and saw the accused persons Amjad, Haidar, Motiar, Nur Bakhtar, Joel Haq, Nur Jamal, Shamsul, and Bakhtar assaulting Rahman and Shukur with deadly weapons, causing grievous injury to them. And Rahman Ali died on the spot, and Shukur Ali died on his way to hospital. PW 9 also categorically stated that Joel inflicted blow on his head with fala. PW 10 stated that Joel Haq inflicted blow on his hand and head with fala. PW 11 stated that Nur Jamal broke his teeth with stone. Nur Bakhtar assaulted him with sharp pointed weapon and Bakhtar assaulted him with fala. Medical evidence. Postmortem examination of deceased Rahman Ali and Shukur Ali. PW 15, the MO who conducted postmortem examination of deceased Rahman Ali and Shukur Ali. On postmortem examination of Rahman Ali, the MO found several sharp cutting wounds on different parts of his body, and according to the MO, death of Rahman Ali was due to shock and hemorrhage as a result of injuries sustained by him. On postmortem examination of Shukur Ali, the MO found several swelling and penetrating wounds on different parts of his body, and according to MO, death of Shukur Ali was due to shock and hemorrhage as a result of injury sustained by him. PW1 MO also on examination of PW 9, 10, and 11 found simple and grievous injuries on their person. Evidence of investigating officer, inquest and seizure of weapons of offense. PW 17 IO during investigation visited the PO and held inquest on the dead body of Rahman Ali in presence of witnesses. At the time of inquest, he found injury on the neck, forehead, chest, etc. He also seized two sharp-pointed instruments made of iron with handle, on being shown and identified by one Sofiur Rahman. On threadbare discussion of the evidence of eyewitnesses as well as the evidence of MO and IO, it is found that they have corroborated one another with respect to all material points. The eyewitnesses have also corroborated one another with respect to presence of other accused person, Amjad, Haidar, Motiar, Nur Bakhtar, Joil Haq, Nur Jamal, Samsul, Rajak, and Bakhtar at the PO, and their participation in the attack. And the MO and IO have fully supported the evidence of eyewitnesses with respect to use of weapon and injury sustained and cause of death of the deceased. Before I proceed further, I may took the points raised by the defense in this case. Defense plea and argument. The defense cross-examined all the PWs and attempted to show that there was land dispute between the accused person and the complainant side. Defense also attempted to show that the PO was a chore area and the area was full of various plants and shrubs, and the alleged occurrence took place in the wee hours, and the PW stated that they saw the occurrence through the shrubs and plants. In cross-examination, defense also attempted to show that the complainant and his family members, including the deceased and injured persons, were engaged in illegal trade with Bangladeshi people, and there was enmity between them, and the Bangladeshi dacoits came and attacked them. The eyewitnesses have denied defense suggestion that the accused persons were not involved in killing the deceased persons, and also denied that they have falsely implicated the accused persons. Further, there is overwhelming evidence on record that the accused that the assault resulting in the death of two persons was premeditated and brutal, as the accused persons inflicted several injuries on vital parts of body of deceased Rahman Ali and Sukur Ali with dangerous sharp cutting weapons. Hence, it can be safely held that the accused persons did the act with intention to cause death of the deceased. Finding. In view of the above, I find that accused person, namely
You're
Amjad,
reading from which page?
paragraph 55 of the judgment. Lordship.
But
I'm sorry,
after
Lordship, I
47
skipped-
you have jumped.
I'm sorry, Lordship. That paragraph 48, Lordship.
Hmm.
I'm sorry. The learned counsel for the defense, while arguing the case on behalf of the accused person, submitted that the neighboring people were not examined in this case, and all the witnesses who claim to have seen the occurrence are relatives of deceased person. The learned counsel for the accused person has submitted that the witness have improved their statement before the court, and there is contradiction regarding time of the incident. The learned counsel has vehemently submitted that in this instant case, it is to be borne in mind that there is dispute between the parties over land, and the complainant and his family members who are witnesses in this case has falsely implicated the accused persons. The learned counsel also submitted that the prosecution has failed to prove the case against the accused persons beyond all reasonable doubt. On the other hand, learned additional PP submitted that in this case, the eyewitness have given clear account of the incident, and from their evidence, it has been proved beyond all reasonable doubt that the accused persons are involved in killing Rahman Ali and Sukur Ali. I have very carefully scrutinized the evidence on record vis-a-vis the defense plea and argument. I have also given my anxious thought to the entire materials brought on record and the facts and circumstances of the case. It is true that all the important and vital eyewitnesses are relatives of the deceased persons, but relationship of the witness to deceased is no ground to reject the convincing, consistent and reliable evidence of eyewitnesses. I also find that defense is not able to demolish the prosecution evidence. It is well settled that relationship of prosecution witnesses to the deceased is no ground for rejecting their evidence. Interstate witnesses are not necessarily false witnesses, though the fact that those witnesses have personal interest or stake in the matter must put the court on its guard. The evidence of such witnesses must be subjected to close scrutiny, and the court must assess the testimony of each important witnesses and indicate the reasons for accepting or rejecting it. And no evidence should be at once disregarded simply because it came from interstate witnesses. It is also in Girja Prasad versus State of Madhya Pradesh, it was held that related and interstate witnesses would be last person to screen the real culprits and falsely substitute innocent ones in their places. Now let me see whether the evidence on record constitute offense of murder as defined under section 300 IPC. There are also have the 5 exception to section 300 IPC. When we
You
speak of
can skip this part.
Lordship.
This part. Then 55 findings.
Lordship. In view of the above, I find that accused persons, namely Amjad, Haidar, Nur Bakhtar, Nur Jamal, Rezzaq, Samsul caused death of Rahman and Sukur with intention of causing death, and the act being premeditated one falls under clause firstly of section 300 IPC, which reads, except in the cases where hereinafter accepted culpable homicide is murder, if the act by which the death is caused is done with the intention of causing death. I also find that above named accused persons committed the offense of murder in prosecution of their common object under section 149 IPC. It is well settled that once a membership of an unlawful assembly is established, it is not incumbent on the prosecution to establish whether any specific overt act has been assigned to any accused. Mere membership of an unlawful assembly is sufficient. So far as motive of committing murder is concerned, in this case, prosecution has been able to prove the occurrence by adducing evidence, and hence it can be held that in this case, the motive is rendered inconsequential. In this regard, I may refer to observation of so-and-so. Proof of motive, however, receded into the background in cases where the prosecution relies upon an eyewitness account of the occurrence. That is because if the court, upon a proper appraisal of the deposition of the eyewitnesses, come to the conclusion that the version given by them is credible, absence of evidence to prove the motive is rendered inconsequential. In view of the above, I find that prosecution has been able to prove offense of murder punishable under section so-and-so against accused persons Amjad, Haidar, Nur Bakhtar, Nur Jamal, Abdul Razak, Samsul beyond all reasonable doubt. I also find from the evidence of PWs, including injured witness and medical officer, that accused persons Amjad, Haidar, Nur Bakhtar, Nur Jamal, Abdul Razak, Samsul Bari came in a body and entered the premises of deceased Rahman Ali and Sukur Ali, and also assaulted deceased and injured witnesses with deadly sharp-cutting weapons, causing simple and grievous injuries on the person of deceased and injured. Hence, I find prosecution has been able to prove offense under so-and-so against the above named accused persons beyond all reasonable doubt. So far as accused persons, namely Sophia al-Haq, Manser Ali, Sattar Ali, Fajr Ali, Ansar Ali, Fajr Ali, and Kubad Ali are concerned, it may be noted that though the witnesses mention the name of Kubad Ali, it reveals that from the evidence that he was neither armed with weapon nor took part in the assault, which in turn my considered opinion would show that he did not share the common object of the unlawful assembly formed by accused persons. As far as 2 accused persons having same name as Fajr are concerned, though PW8 has mentioned that Fajr Ali assaulted Rahman, fact remains that she has not specifically mentioned as to which one of the 2 persons have same name as Fajr Ali actually took part in the assault, and hence, in my considered opinion, the evidence on record as to the involvement of these 2 accused persons creates a doubt. So far as accused persons Sophia al-Haq, Manser Ali, Sattar Ali, Ansar Ali are concerned, I find that prosecution has failed to bring any credible evidence to show the involvement of the accused persons in the commission of the alleged offense. So accordingly, they were convicted.
So, Mr. Ahmed,
That's it.
what is your submission here?
Here, my submission to your lordship is that although the learned trial court has treated with the witnesses as 9, 10, and 11 as injured witness, but from the record your lordship will find they failed to prove that they sustained the injury in the occurrence itself, because one of the
So,
witnesses
injured eyewitness.
no, he himself said, lordship, that when the incident took place, out of fear he ran away. before sustaining the injury. Subsequently, he admitted these facts and he said that after the accused persons left, he came to the place of occurrence. So where he got the injury? He cannot be
But there
treated.
are other witnesses who have been treated.
Other
by-
witnesses, regarding other witnesses, your lordship will find that here there are contradiction among the witnesses, because they said, lordship, they three went to the place of occurrence together. But some of says that one of the deceased was with them, then PW4 was with them. Those contradictions are there. How they went to the place of occurrence and how they have seen. Because admittedly there was lordship Kohua bone, that scraps were there. And because of that, it was not visible. It is in the evidence of those eyewitnesses itself that the place of occurrence is not visible from a distance, lordship.
Okay, let us see the evidence.
Lordship. The PW1 I am skipping for the moment, lordship. He is the doctor. PW2, Lord, he also stated nothing about the incident. So lordship may come to PW3,
Page.
page 18, lordship.
Yes.
Nazir Mohammed. I know the accused persons present in the dock. Earlier, they lived in our village. Now they live in our village. This is Sukur Ali and Rahman Ali were my nephew and brother, cousin respectively. It has been about 5 years since the incident. On the day of incident, I was in the house itself after offering Fajr Namaz. I heard a commotion. After having tea, I went to the nearby bus stand and saw some people of Telipara coming there. Thereafter, I headed towards the place where the commotion took place and arrived at our old house at Telipara. I heard that my cousin, son of father's elder brother, Rahman Ali, had died. I heard from my cousin, son of uncle Shahjamal, not examined, Azizuddin, PWC, and others that Rahman and Sukur had been stabbed. I also heard that Anwar Ali and Nur Islam to sustain injuries. I went to Kukurmara hospital and saw injured Sukur Ali, Anwar Ali, Nur Islam there. On being asked, Nur Islam and Anwar said that Nur Jamal had stabbed Sukur Ali. Sukur was referred to Dhubri. I heard that Sukur had succumbed to his injury on the way. The incident took place over the land which with our joint ownership. Cross. The documents pertaining to the land stand in the name of our grandfather. I did not see the documents being given to police officer. I do not know the Khatia number. The class of said land still remains as khas. The land had been eroded by river and had been under the water for about 30 years. The accused persons did not occupy any land or out of the said land. It is not a fact that I stated to the police that the accused persons started to establish their possessory right over 2 bighas land out of the said land. Considering the land as khas land, the accused persons had been trying to occupy the land for 9-10 years. It is not a fact that the land does not belong to us and that we have no document pertaining to the said land. The accused persons occupied 12 bighas land there. So now they are saying it is not a fact that at the time of incident, the accused persons had their homestead on the said land. My brothers lived at Telipara, which is about 1 mile away from Kothalbari, where I live. The disputed land and the place of occurrence are within 1 mile distance from Telipara. Kukurmara Gajarikandi Hospital is at a distance of 1 kilometer from my house. I heard commotion when I was at the place of my offering namaz. I heard on the road that some people of the village had taken the injured persons to hospital. The distance between the place of occurrence and the hospital is about 1 mile. I saw the doctor stitching the wound of Nur Islam and Anwar. I also noticed that arrangement was being made to send Sukur to Dhubri Civil Hospital. Usually, Fajr Namaz is offered before sunrise. It is not a fact that Anwar and Nur Islam did not tell me that Nur Jamal had stabbed Sukur and that none told me that accused persons had killed Rahman. Now, PW4.
So what do you want to show from this witness?
No, I am just placing the facts from the evidence of these witnesses. Your lordship will find, after perusing these witnesses, the incident narrated by the injured witnesses, there are material discrepancies are there.
That's
Because
all right,
let's say
but the witness
PW4.
could not be shaken.
Yes, his evidence is there that he heard from that eyewitnesses.
Mm.
But later on, your lordship will find that in the evidence of eyewitnesses themselves, there are contradictions. So if they goes, then he will also go, lordship.
Mm.
PW4, lordship.
Yes.
I know the accused persons present in the dock. Rahman Ali was my brother and Sukur Ali was my son. They are no more. It has been about 6 years since the incident. One day about 6 years back, a short while after sunrise, my brother Rahman Ali and I got ready for offering namaz. Now your lordship may kindly note this. He is saying that this is Rahman Ali and he was getting ready for offering namaz. But later on your lordship will find that Rahman Ali was already there in the house, place of occurrence at night. We used to live in the same house. My son Anwar went to the field and was standing there. Anwar is lordship PW11. My son Anwar went to the field and was standing there. Rahman Ali and I too went there. On being instructed by Amjad, Haidar stabbed Rahman with a spear. Thereafter, Nur Bakhta and Samsul Bari also inflicted stab blow to Rahman. They also stabbed Anwar Ali. Nur Jamal stabbed Sukur Ali with spike. He ran but fell down on the ground. Later, I became unconscious. Rahman died on the spot. Sukur Ali died on the way to hospital. Cross. There was a house in the disputed land and Sukur Ali and my brother Rahman Ali stayed in that house on the day of the incident. They had stayed there since 2 days prior to the incident. They spent 2 nights there just before the incident. It is not a fact that I stated to the police that Rahman, Anwar, Ainal, Nur Islam and Sukur Ali had stayed in that house on the previous night of the incident. The disputed land and the PO is about 1 kilometer away from my house. Prior to the incident, Anwar, Ainal, Nur Islam and Sukur had come home from the disputed land and offering namaz they returned to the said land. After offering namaz, I first went there and they followed me. The accused person started to assault me. They got into a fight with me at a place which is about 100 cubits away from the house at the place of occurrence, and the said place was in the west-north direction from the house. One woman came and helped Rahman to sit. Nobody assaulted me. I was not pushed when I proceeded to offer resistance. It is not a fact that I stated to police that accused persons had assaulted my man to death and fled towards Bangladesh with weapons. So this part is confirmed. So just I am taking your lordship to page 66.
What is confirmed?
He stated before police that prior to arrival of this witness, the accused persons already killed the deceased and they fled away towards Bangladesh.
Say it is not a fact.
No, this fact is confirmed through IO. Page 66, your lordship will find. Page 66,
Just a minute.
lordship.
So he is referring to accused persons.
Accused person.
Your theory is dacoits came from Bangladesh, committed the crime and then returned back.
Okay.
That is very different from what is he saying. Accused person, page 66.
66.
Let us see.
Lordship.
Yes.
Page 66, PW4, Usman Ali said that Rahman, Anwar, Ainal, Nur Islam and Sukur Ali had been in the house in the night before the day. So first thing your lordship kindly note that he in his examination he said that Rahman Ali was with him. But before police he said Rahman Ali, Anwar, Ainal, Nur Islam, Sukur Ali had been in the house in the night before the day on which the incident took place. That they had gone there on that day also. That hearing commotion from the house, he had gone there. That the accused persons had killed his people, not cattle, it should be people. had killed his people by means of weapons and fled towards Bangladesh. And if your lordship see the 161, that is there, lordship. On hearing hue and cry, I came in a run, but they caused death of my people and fled away with arms towards Bangladesh by crossing the river. So here accused word is not there.
So
And
what is the inconsistency you want to show in this page 66 PW4? This is by IO, is it?
This is by IO. PW 17, lordship. Page, it starts from page 63.
Yes.
He confirmed that he stated before in this manner. And I am pointing out this because, lordship, from the other evidence that I've injured eyewitnesses, your lordship will find that they have that Anwar, Ainal and Nur Islam, they said they along with the PW4 went to the place of occurrence. So if in the police statement it was there that they were already there, there is no question of following the going to the place of occurrence along with PW4, lordship. I'm only on that point, lordship. Because there in deposition he is saying Rahman Ali was with him. Subsequently, they went to the place of occurrence. Before police, he said, lordship, that that Rahman, Anwar, Ainal, and Sukur, that two deceased and along with PW 9, 10, and 11 were already in the house. If they are already in the house, then PW 9, 10, and 11 cannot come subsequently to witness the incident. There are other discrepancies also in their evidence itself, your lordship will find.
He is saying on the day of the incident, not the time of the incident. There's a difference between at the time of the incident and on the
No,
day of the
in page 66, lordship, may I read it again, lordship?
Yes.
Usman Ali said that Rahman Ali, Ainal, Nur Islam, and Sukur Ali had been in the house in the night before the day on which the incident took place. They had been there on the day also. Hearing commotion from the house, he had gone there.
An incident took place early in the morning.
Early in the morning.
You may proceed.
Lordship. And again, lordship, may I continue PW4, lordship? Page 23, lordship. I did not state to police that Rahman and Sukur had been assaulted, killed, that Haidar had uttered Han, stabbed, that the accused person had stabbed Anwar with spear, that Nur Jamal had stabbed Sukur, and that Sukur had run but fallen down on the ground. It is not a fact that I did not see Sukur, Anwar, and Rahman being assaulted. It is not a fact that it is false that they had been assaulted. I did not state to police that after offering namaz along with Rahman, I accompanied by Nur, Rahman, Nur Islam, Anwar, Sukur, and Ainal had gone to the disputed land. It is not a fact that the disputed land belongs to accused persons, not ours. It has been more than 50 years since the river had eroded the disputed land. There are some 1,500 to 2,000 bighas khas land there. No survey has been done. PW 5. I have recognized the accused persons by their names and faces. Page 24, I am reading, lordship.
Yes. Yes.
I have recognized the accused persons by their names and faces. Sukur was my paternal uncle while Rahman was my brother. Both of them expired some 5-6 years back. When I went for fishing in the morning, I heard uproar in the nearby plot of land and seeing people gathered there, I went there. Haidar Ali, Nur Bhakta, Motiyar, Samsul Bari, Johirul Haq, Ansir, Kobat, Nur Sheikh, Nur Jamal, Sofiul, Rezak, Amjad, Fajr and another person by the same name Fajr were standing there. Amjad shouted, "Save!" Rahman Ali, Anwar Ali, Sukur Ali, Nur Islam and Sofiur were near their house. Then Haidar stabbed Rahman with a spear. Nur Bhakta, Samsul Bari and Motiyar also stabbed Rahman with spears. The rest of the accused persons hit Anwar with stones, as result of which his teeth got broken. Nur Jamal stabbed Sukur with iron spike. Johirul Haq struck Nur Islam in his hand with spear. Rahman remained lying there. Sukur was taken to hospital, but Rahman had expired on the spot. There had been land dispute. The land belonged to Rahman Ali and his co-sharers. Sukur and Rahman had their houses on the disputed land. Upon finding spear and sulpi, a weapon with pointed iron end, at the PO, the police seized the same. Exhibit 3 is the seizure list, wherein Exhibit 3 was cross. It is not a fact that I stated before police today, that is on 11/10/97, I was at home in the morning. Then I heard a hue and cry towards Teleparasor. I also heard accused Nur Bhakta, Amjad, Bakhtar, Nur Jamal, Fajr, Haidar, Samsul Bari, Johirul, Rezak, Fajr, Sofial, Ansar, Monser and Motiyar had killed Rahman Ali and caused grievous injuries to Sukur Ali by attacking them with lathis, spears, spikes, etc. That he had Sukur had been sent to Dhubri, and they had also caused grievous injuries to Nur Islam, Ainal Haq and Anwar Ali. Here I am pausing for a moment, Lordship, that this fact is also confirmed through IO, that before police he stated that he heard, and here in examination in chief he is projecting himself as an eyewitness. And page 66, your Lordship will find that IO has confirmed that before, during investigation, he said he heard. Page 66. PW5 Muqtadur Alam said to me, today morning I was at home, then I heard the residents of Talipara raising hue and cry. Here I heard that accused persons, namely so-and-so, had also given grievous injury. I also heard that Nur Hussain, so he heard. He has not seen the incident.
Yes.
Just other rest of the part I am not reading, Lordship. Lordship, may kindly see page 27, first line of the cross part of PW5, Lordship. Rahman and Sukur Ali were in that house itself at night. That PW4, he said Rahman Ali was with him. And subsequently, Rahman Ali and the PW4 went to the place of occurrence.
But here he says he has witnessed the incident.
Lordship. Here it is said, but during investigation, he said he heard. That is why it was confirmed through IO.
No, Mr. Ahmed, see, the
Lordship.
point is not whether he said he heard or he saw, that's not the point.
Lordship.
Point is there anything to suggest that he was not there in the place of occurrence at the relevant point of time?
Lordship.
Because these witnesses, they are illiterate persons.
Lordship.
So their expressions sometimes may vary. They may have something in mind and say something else. If he has seen something and said, I have heard, that doesn't mean he has not seen. If you want to impeach his testimony,
Lordship.
then you have to show us that he was not present in the place of occurrence as claimed by him.
So,
If you can show that, then this will have a relevant bearing.
Lordship.
Otherwise, merely saying, he has said, I have heard, he has said, I have seen.
Right.
So both the versions he has given. And in your cross, you could not demolish him on that.
When a witness, Lordship, to subject to correction, Lordship, when a witness said that I heard, so if he if the defense, Lordship, further
That
cross-examine
means we
him,
have heard and seen both. Because both evidence are there for both. It doesn't mean I have heard, but I have not seen. It doesn't mean that. You may like the court to take that view.
but in that case, he will be hearsay witness, Lordship, not eyewitness,
Anyway, we have pointed out, if you have understood,
Lordship.
you have understood. You can make your submission.
Lordship.
But I am telling you, on behalf of the bench,
Lordship.
I hope my brother will agree. Since there are also unimpeached testimony which shows that he has witnessed the incident. Unless you show that he was not present in the place, merely by making a 161 statement to the IO, that's not going to have much of a bearing. This has to be embellished with other materials to show that he has actually heard and not seen anything. Because he has given both the versions.
That I have to see, Lord.
Make a point, make a note on. So what I'm saying is, these convictions cannot be overturned merely on cosmetic discrepancies. That era is gone.
Lordship.
You can take it that those era is gone, where it was very easy. Today the court will strike a balance and go deeper and see what is the. Today, no, that is what the court is supposed to do. So
Lordship.
merely because somewhere there is a little discrepancy here and there, that's not the end of the matter. In substance, we'll see what the witness actually tried to depose. He might have said, I have heard. There could be various reasons. Maybe he was afraid at that time when he gave the 161 statement. But what will matter is what he said before the court. Before the court, he said he has seen the occurrence and he could not demolish it. Correct.
But in that case,
And he is
Lordship,
denied. When you confronted him, he is denied.
he denied, but IO has confirmed it.
He said that.
Lordship.
But he might have said it for various reasons.
Lordship. But
There is no suggestion that you were not present in the place of occurrence. There is no such suggestion. Is there any suggestion in the cross? That means you are accepting the fact that he saw it. He made a false statement before the IO.
Lordship.
So, what difference does it make? He was not bound to state the truth before the IO, but he is bound to tell the truth before the court.
But
Where is your statement that you were not present and you did not see the occurrence? Where is the statement?
But a witness, when Lordship, he made two kinds of statements, Lordship. Then
We'll deal with it.
I will check it and
You have to demolish him when he is in the witness box. There is no suggestion that you were not present, you did not see the occurrence, you are falsely deposing, nothing of that sort.
Okay.
So just by clinging on to some discrepancy here and there, which can be easily explained.
No,
Can be
that
for very
suggestion,
many reasons.
that suggestion is there, Lordship. Page 27, last two line, Lordship. And we have adduced false evidence to grab the land. False evidence that
Grab the land is another thing. Where is the substantive?
they have adduced false evidence to grab the land.
All right, you proceed, please.
And one more suggestion is there, Lordship, that page 27, second line, Lordship.
Yes.
The house is not visible from the place where I was fishing.
He seems to have deposed in the in chief as well as in cross in
Right.
affirmation of his stance that he has seen the occurrence. There is no suggestion that he had not seen the occurrence. That's what we are pointing out to you.
Lordship,
Make a note of that
Lordship,
so that at least you know.
Lordship.
You see, if the defense case was that he's not an eyewitness. They could have said that instead of saying the house is far, the canal is near. These are all indirect things. Why was that not question not put? Because the defense was aware. And then his testimony is affirmative and corroborative in nature. That's what we will take into account. That's what we are indicating to you.
Lordship.
He might have told the IO that he has heard, but he never said he had not seen.
That suggestion was there, Lordship.
Hmm?
That suggestion that he has not witnessed. Page 26, Lordship.
Hmm.
Middle portion, your Lordship will find after that big paragraph, Lordship.
Hmm.
First paragraph. It is not a fact that I was not present there and that I did not witness any incident.
Okay, so he denied it.
He denied it.
All right, so he has at least twice denied this suggestion.
Yeah.
All right.
Now, PW6, Lordship.
Hmm.
Page 28. Sukur Ali and Rahman Ali passed away. Rahman was my brother. I know the accused persons. The incident took place some 4-5 years back. Around 6:30 a.m., I was going to Satirbari along the bank of river. I saw Haidar, he is convicted, Lordship. Joel Haq, he died. Nur Bhakta, convicted. Motiar died. Shamsul Bari, convicted. Nur Jamal, convicted. Sattar, acquitted. Kubad Ali, acquitted. Ansar Ali, acquitted. And Monser Ali, acquitted. Arms with lathis and spears coming to Rahman Ali's house. Rahman was stabbed with spear in his house. Rahman expired. As there was uproar, I left for home. Cross. It is not a fact that I stated before police that I had gone towards Satirbari at 5 a.m. It is not a fact that I did not tell the names of Joel Haq, Nur Bhakta, Motiar, Shamsul Bari, Kobad Ali, and Ansar Ali to the police. Rahman is my son of my cousin, the son of my father's elder brother, while Sukur Ali is my nephew. I went to Satirbari to collect money from a person Amjad by name. His house is about 4-5 cubits away from the place of occurrence. I did not go to Amjad's house then. I did not know if any member of from Amjad's family had come there after the uproar had been caused. I was standing some 100 cubits east from the place of occurrence. Kohua, Kansk grass, and Dhonsira, prickly sesban plants there were there. At that time, I was alone there. I did not give a shout out of fear. I do not remember if in which side of the house Rahman and Sukur were. I did not see whether the accused persons entered the house or not. I saw some 5-6 people from the complainant's party outside the house of Rahman when Sukur and Rahman were being assaulted. Rahman erected the house some 8-10 days prior to that incident. I did not see as to what those peoples were doing there. Rahman and we have some 10-12 bighas of land there. Rahman is our co-sharer of land. I do cultivation in about 3 bigha land out of the said land. Rahman and Anwar used to cultivate in the rest of the land. It is not a fact that I had not witnessed the incident, that no accused had gone there, that neither Rahman nor anybody else had been assaulted, and that I have adduced false evidence in favor of Rahman since he was my co-sharer of land. It is not a fact that since we have dispute over that land with Nur Bokta and others, and that out of suspicion I have adduced false evidence against the accused persons. It is not a fact that someone killed Rahman and Sukur at night, and that we have implicated the accused persons in that manner. So he has named some persons, out of them 4 persons are acquitted. And he categorically said that I did not see as to what those people were doing there.
But the learned trial court says that though their presence has come out from the evidence, no overt act has been alleged in respect of those persons. That is why they were acquitted. Is it not?
Lordship. And next, your Lordship will have PW7.
PW7 is not an eyewitness.
Not an eyewitness.
Just 1 minute.
Lordship.
Yes.
His Lordship may skip his evidence, Lordship. PW8, wife of Rahman Ali. Page 34, Lordship.
She is also an eyewitness.
Lordship. Rahman Ali was my husband and Sukur Ali was my nephew. Both of them expired in the same incident some 6 years back. Due to the shortage of space in our house, my husband and nephew were in another house standing on our land. We were in our old house in the morning. After I had gone there, I heard uproar in the house in which my husband had been. Haidar, Nur Bokta, Joil Haq, Samsul Bari, Sattar, Boktar, Nur Jamal, Fajr Ali, Amjad, Ijaz and others were there. They called my husband Rahman. Since he did not come out of the house, as per order of Amjad, the rest entered inside and assaulted my husband. Haidar assaulted my husband with spear. Nur Bokta stabbed him with sulpi, a weapon with pointed iron rod. Nur Bokta stabbed my husband with spear. Fajr also stabbed him with spear. Boktar, since deceased, and his son Nur Jamal also stabbed him. Rajak also stabbed him with spear. As my nephew tried to flee, Nur Jamal stabbed him with hunkal, a weapon with pointed iron rod. Seeing the blood, I felt dizzy. My husband died on the spot. My nephew Sukur breathed his last on the way while he was being taken to Dhubri. That day, police came and took the dead body away. My brother-in-law, husband's elder younger brother informed the police. So here, your Lordship may kindly note that she stated about using of pointed weapons. And whereas that stab injury was there. So it ought to have been a Lordship punctured wound. But that is not there in medical evidence. There, I will place that before your Lordship. All the weapons and they mention and seized by investigating officers shows it is pointed weapon. Cross, Lordship. The distance between our house and the old one is half a mile. Kohua, Kansgrass and Dhonsira prickly sisban cultivation were there in between the two houses. The height of prickly sisban is longer than jute, and it was small twigs. The new house was erected some 3-4 days prior to the incident. After erecting the house, my husband and the nephew had stayed there for 2 nights. They took along the mid-meal from the old house. There were beds, chairs, tables, etc. in the house. 2 houses were built. They stayed separately in 2 houses. The accused persons carried out the house in which my husband was. The walls and the doors of the house were made of bamboo. No sooner had my husband opened the door than the accused entered inside. I was standing some 4-5 cubits east from the house. The fight lasted for less than an hour. The door of the house in which Sukur was faced north, while one in which my husband was faced south, but the doors stood face to face. As Sukur tried to flee, he was stabbed for once only. That night, my husband did not come to our old house late night. In the previous night of the occurrence, Anwar and Fazal did not call my husband away from the house. It is not a fact that Fazal killed my husband by calling him away and that Anwar, by taking money from Fazal, forbade us from lodging case. There has been dispute between my brother Sophia and Rajak. It is not a fact that upon being instigated by brother Sophia, I named Rajak as an accused. The house of Somizuddin, Fazlul, Firoz Ali, Joinal and Sadek are there by the side of the house where the incident had taken place. They were not examined, Lordship. Going to the PO, I did not see those people there. No sooner had the incident happened than Anwar, Ainal and Sophia went there. It is not a fact that I stated to police that Sukur, Nur Islam, Sophia, Anar and Ainal were also in that house itself that day. It is not a fact that, as I have stated above, the accused did not assault my husband with spears and sulpi. It is also not true that Nur Jamal did not assault Sukur with a hunkal. It is not a fact that they did not make the assault by entering inside the house. It is not a fact that my statements that Amjad had given the order is false. First thing, Your Lordship will see that she stated that the incident occurred inside the house. But in the sketch map, Your Lordship will find that incident occurred 50 feet away from the house, Lordship. And second thing, Lordship, she stated about causing injury with pointed weapons, Lordship. But in the body of her husband, Lordship, that pointed injury was not there. Punctured wound.
There is a judgment of this court where I was a party on the discrepancies in testimonies, how it is to be dealt with. Are you aware? Division bench.
Monirul.
Have you got the judgment?
On 145.
How the contradiction is.
Contradictions.
Yes, by your lordship judgment.
Yes.
Yes, yes.
No, there are a number of judgments, but the one I am referring to is where the court has laid down the guiding principles. What would happen if there are discrepancies and how these discrepancies are to be
Dealt
decoded
with, ma'am.
by the court? All discrepancies are not fatal.
Yes.
The discrepancy
Bharti Sharma.
in the witness testimony has to be of a particular nature and degree so as to enable the court to discard it. That was the discussion. Just see if you can get hold of it.
Yes, sir. Yes, sir. Isha.
Yes, please. Yes, Mr. Arman.
Okay. And other thing, Your Lordship will find that she stated that all the accused persons gave step blow. And your lordship will find in the body of that deceased, lordship, her husband Rahman Ali, only 4 injuries were there, cut injuries. And she alleged that Haidar, just I am again reading lordship, that as per the order of Amjad, Rest entered inside and assaulted my husband. Haidar assaulted my husband with spear. So number 1, Nur Bhakta assaulted with Sulpi. 2, Nur Bhakta stabbed my husband with spear. 3, Fajr Ali also stabbed him with spear. 4, and his son Nur Jamal also stabbed him. 5, Rajak also stabbed him with spear. 6, my nephew fled, so there is so this 6 injuries here she has alleged, lordship. But in the postmortem report and evidence of the doctor, your lordship will find on the body only 4 cut injuries were there, no puncture wound. My whole case is that, lordship, the eyewitness, the witnesses who projected themselves as eyewitnesses.
Mr. Amit, please come to page 38 once again, huh?
38,
38,
lordship.
where you have just read. This is PW9.
PW8 is 34, lordship. PW8 is 34.
That's correct. We are referring to PW9, page
Lordship.
38.
Lordship.
You see the second line.
Lordship.
Can you please read it?
On our arrival.
Hmm.
On our arrival, there we saw Amjad ordering Haidar, Joel Haq, Nur Bhakta, Motiyar, Samsul Bari, Fajr Ali, Rajak, Nur Jamal, Bakhtar, Singh Jisi and others to assaulted us. Then Haidar stabbed Rahman on his neck with sulpi, weapon made of a rod with pointed end. Joel stabbed Rahman on his chest with a spear. The spear is made of rod. Nur Bhakta stabbed Rahman with sulpi. Motiyar stabbed Rahman with sulpi. 7 wounds were caused to
So
Rahman.
therefore, before that, these
Lordship.
are the 4 wounds in Rahman.
Lordship.
Is it not? It has
Lordship.
clearly come out from the testimony of PW9.
But he was
Yes.
whether he was present or not, I will place before your lordship this. And he said, lordship, 7 wounds were caused to Rahman. 7 numbers of wounds were not there in the postmortem.
Is it 7 or several? We have to see from the
I have checked it 7. Subject to correction of my
testimony. In the vernacular, it is mentioned 7.
lordship.
Do you have the original version?
Lordship. And
Got it? Yeah, we are on a slightly
Yes,
different.
yes.
Uh,
2019. Is the lordship,
page 38.
page 38. Yes.
PW9 has named the 4 persons who had caused injury on. This is Rahman. Page 38. Page 38 of the paper.
PW9 Ainal Hawk is 161, your lordship. No, deposition. This is the one.
You come to page 38, please.
38, my lord. Yes.
The second sentence.
On our arrival.
Yes.
On our arrival, there we saw Amjad ordering Haidar, Jail Hawk, Nur Bakhta, Motiur, Samsul Bari, Fazar Ali, Razak, Nur Jamal, Bakhtar, and others to assault us. I know. Then Haidar stabbed Rahman on his nape with chulpi. Joel stabbed Rahman on his chest with spear. Nur Bakhta stabbed Rahman with chulpi. Matius Teb Rahman, which will be 7 wounds were caused to Rahman.
All right, now pause here.
Yes.
Now, this witness has named the 4 persons who had assaulted the deceased Rahman. That tallies with the medical report.
Yes.
Then where from this 7 comes? Is it in the original version from the LCR? Can you please check?
7 wounds were caused.
Is it 7 or several?
Maybe I'll see. The PM report.
Not the PM report, the testimony of
Testimony.
PW9
Original report.
original. Just have a look and keep a note. Yes. Yes, proceed,
Yes.
Mr. Ahmed. Yes.
And again, I'm taking your lordship to PW8, lordship. That one more contradiction is there. That page 36, your lordship may kindly see.
Yes.
Last paragraph, lordship.
Hmm.
It is not a fact that I stated to police that Sukur, Nur Islam, Sophia, Anar, and Ainal. So this PW 9, 10, 11 were also in that house itself that day. So they were there in the on that day, lordship, and it is confirmed through IO at page 67. So my whole submission to your lordship is that if they are already in the place of occurrence, so subsequently coming to the place of occurrence does not arise, lordship, because they are the related witness, and their evidence has to be, lordship, cautiously.
So
for
what is the
that
contrary? He is denied. I haven't
denied,
stated.
but that is confirmed through IO, lordship. IO said during investigation, she stated like this, lordship. Page 67, lordship, may come for a moment, lordship. Page 67, middle portion, your lordship will find PW8. Ahiton Bewat told me that Sophia, Nur Islam, Sukur, Anar, Ainul had been in that house on that day.
Well, we'll examine
Gotcha.
these issues. But at the end of the day, we will see on appreciation of evidence
Lordship.
whether the charge has been substantively established beyond reasonable doubt.
Lordship.
Little here, little there is always there in every case.
Lordship.
Unless it goes into the root, that's why that judgment is important. Their law has been discussed. Please
And
get the judgment.
And in present case, if your lordship see the medical report, your lordship will find doctor opined that they are saying that the Rahman Ali died on the spot, lordship. But in the medical report, your lordship will find that.
So we'll
Had he-
examine. Mr. Ahmed,
Lordship.
we'll give you 7 days. Show us a criminal appeal or criminal matter where picture perfect trial has been conducted. It's not there.
That is there, lordship.
But as we have mentioned, picture perfect trial is not possible.
Lordship.
These witnesses are illiterate people, villagers. They are bound to give some statements which are here and there.
Lordship.
But the court is not judging how perfect the witnesses are
Lordship.
or how literate they are.
Lordship.
The court is judging whether on the basis of evidence
Lordship.
it is possible to legally sustain the conclusion
Lordship.
that has been drawn by the trial court.
Lordship.
If the answer is in the positive, that's the end of the matter.
Lordship.
The court finds that no, there are contradictory theories which gives more than one version. Then only you will succeed,
Lordship.
not by minor cosmetic
Lordship.
deviations.
And I
here and
understand
there.
that.
Yes. Yes, please.
Lordship. That, PW8, I have completed, lordship. Now PW9, just three things your lordship has already read. Just I am pointing out three things, lordship, here. Page 37, lordship. Last 2 line. Rahman and Sukur Ali stayed there. So these 2 deceased already stayed there. The house were built there 3 days prior to the incident. On hearing a hue and cry, I, accompanied by Anwar. Anwar is PW11, lordship. Sophia, he is PW13. Soidur Islam, he is not examined, subject to correction what my learned friend says, lordship. Nur Islam, PW10. And my father, Usman, PW4, went there. So these persons together went there. Now I am just taking your lordship to PW4 for a moment, lordship. Page 21.
This is a reported judgment. I don't get the. Yes,
PW4, lordship. Page 21.
yes.
Last two line, lordship. We used to live in the same house, that is Rahman Ali, he and he. My son Anwar went to the field and was standing there. Rahman Ali and I too went there. So Rahman Ali subsequently went along with Usman. And if that is true, then it cannot be lordship, true that I accompanied by Anwar, Sophia, Nur Islam, and my father Usman. And he is saying Sukur Ali was already there. On our arrival, we saw Amjad ordering Haidar, Jalil, Joil Haq, Nur Bakhta, Motiar. He is not before your lordship,
So
Motiar.
if your submission is to be accepted, then this will in some way discredit the testimony of PW4,
Lordship.
but not the testimony of PW9.
Lordship.
That's
But
right.
PW9 also, lordship, to that extent that he is saying that PW4 was with him. If PW4 goes, then also it casts doubt in the evidence of PW9, lordship. If he knows that his father was not with him, why he is, lordship, mentioning that part, lordship?
If there is a
That part.
contradiction between statement of one witness with the other,
Lordship.
both the witnesses don't go.
Lordship. But I will place
It's not necessary that both of them are saying the wrong thing.
no other witnesses also. There are contradiction along with this PW9 that
Alright,
that I
you
will
point
place
out,
for your
that you
lordship.
point out.
Lordship. Haidar, and that out of that, those names, lordship, Fazor Ali is acquitted.
Hmm.
Assaulted us. Then Haidar stabbed Rahman on his neck, such that 7 wounds. Already your lordship has seen that in the original also, that 7 wound is there to Rahman, but in the only 4 injuries are found in the
No,
body of
so
Rahman.
evidence against Faizar Ali is only to the extent that Amjad had ordered Faizar Ali along with others to assault them.
Lordship.
But there's no evidence which shows that Faizar Ali actually did commit assault.
Lordship.
That evidence is there in respect to others.
Lordship.
So that is why the evidence is not the same.
No, but here your lordship will find he specifically implicated 4 persons with 4 injuries.
Hmm.
And rest he said 7 wounds were caused to Rahman.
That's right.
Lordship.
So rest who has caused injuries is not known. That testimony is not there.
Lordship.
But that will not take away the evidence of PW9 insofar as he implicates the 4 accused, convicted accused
Lordship.
for assaulting the victim, the deceased person.
Not all the 4 lordship appellant here, because one of them, Joil Haq, stabbed Rahman. Joil Haq already died, lordship.
Doylok died.
Joil Haq died.
Then Amjad died.
And Motiar is not before your lordship.
Actually,
That he stated about Motiar, that Motiar is not appellant before this.
he has not appealed against the
No,
conviction.
lordship. He is not facing trial. He has not faced trial.
Actually, he was absconding.
That is not, there is no mention about him, although in the evidence his name is there. In the FIR also I have checked, lordship. His name is not there in the FIR as well as in the charge sheet.
Is it that Motiar was absconding? Yes.
And so rest remains, lordship, of that Nur Bakhta and Haidar.
Dear Rahman,
He was sent up for trial. Then why is he saying he was not made to face trial?
He didn't. We spoke. Dear Rahman. You do. Serial number 11.
But here your lordship will find 7 persons are acquitted. They are Fazor Ali, Sofial Haq, Kobad Ali, Fazor Ali, Monter Ali, Ansar Ali, Sattar Ali. And appellant before your lordships are Amjad Ali, Haidar Ali, Nur Bakhtar, Nur Jamal, Abdul Razak, Samsul Bari. So his name is not.
So what has happened to Matiur? He is neither convicted nor acquitted.
known.
Or is it a name with an alias?
No, probably Elias is not.
Son of Ferry, Hyder Ali.
Acha, you just check it up. We'll see.
Lordship.
Yes.
Lordship.
Then let's come to PW 10.
No, in PW 9, lordship, one more thing your lordship may kindly see. Page 39,
Yes.
last 6 line I am reading, lordship.
Hmm.
Seeing the accused persons armed with weapons, we fled towards our house. We returned thereafter. The accused persons had left and found Rahman dead and Sukur Ali in a moribund state. It is not a fact that I have adduced false evidence today. The persons who had accompanied me also fled. All of us returned there again after the accused had left the place. I had fled before I sustained the injury. Lordship, that was I was pointing out earlier.
So PW 9, even if this is to be accepted, at least is a res geste witness. Is it not?
But his evidence, lordship, is contrary to other witnesses that already I have placed with PW 4 and 10 and 11 I will place before your lordship. If his lordship that he has not sustained injury, lordship, during that occurrence, that when he sustained injury, that explanation is not given by the prosecution. Rather, he was shown as an injured eyewitness, lordship.
There is no injury report.
There is injury report, but he has not sustained injury in the occurrence, lordship. To become an injury witness subject to correction, lordship, that he has to sustain injury in the occurrence.
So where did he sustain injury?
That prosecution has not said, lordship, because he said.
How are you saying that he has not sustained injury in the occurrence?
Because he is saying, lordship, I had fled away before I sustained injury. And prior to that, he said, lordship, when we returned thereafter, the accused persons had left and found Rahman dead. So prior to his arrival, that accused persons left. Thereafter, no incident occurred.
Hmm. Yes.
Lordship. And PW 10, lordship. Page 40. I knew Sukur Ali and Rahman Ali. Both of them passed away. Seeing the accused in the dock, I know the accused persons. The incident took place around 5:36 a.m., some 6 years ago. At that time, I was near our house. Rahman and Sukur were in their houses standing on cultivable land on the bank of river Jinjiram. Hearing a hue and cry in their house from my house, which is some 10-15 bighas, 1 bigha equal to 100 cubits apart, I rushed there. Anar Ali, Sobir Ali, Ana Haq, Kabi Khatun, and others also arrived there. I saw that some 10-15 people, including Haidar Ali, Joil Haq, Nur Bakhta, Samsul Bari, and Nur Jamal had out the two houses of Rahman and Sukur. As Rahman and Sukur were about to come out of their houses, they were assaulted. Haidar assaulted Rahman with spear. Joil Haq also struck Rahman with spear. Nur Bakhta also stabbed Rahman with a spear, pointed iron end fitted to 5-6 long bamboo handle. Motiyar also assaulted Rahman. Nur Jamal assaulted Sukur with Sulpi, a spear-like weapon, and its pointed end resembles to a rod. Samsul failed Sukur by assaulting him with a lathi on his leg. As I went forward to resist them, Joil Haq assaulted me with a spear. As a result of which I sustained injuries on my right middle finger and head. I became unconscious. I reached Kukurmara Hospital at 12 o'clock. I regained my senses that very day. Rahman died on the spot. Sukur expired while he was being taken to Dhubri Hospital. Cross. Police did not question me in connection with the incident. It is not a fact that police took my statement at that and that I stated to police. Around 5 a.m. on 11/10/97, I was working in the two houses jointly built by Uncle Rahman and Bakhtar Master. As Uncle Rahman sat down after offering namaz, a group of large people coming from the eastern direction gherowed us. That is Uncle Rahman, Ainal Haq, Sophia Rahman, Anwar Ali, and me. So here also they were already there. It is not a fact that I did not state before the police that Joil Haq, Basir, and Rohimuddin had assaulted Rahman, that Samsul had failed Rahman by hitting him with a lathi, and that Joil Haq had struck me on my finger with an head. So now your lordship may kindly see page 67 that I have also confirmed this aspect that during investigation he stated like this. Page 67 your lordship will find. Second last paragraph, lordship. PW10 Nur Islam said to me at about 6 a.m. on 11/10/97, I was working in the houses belonging to Uncle Rahman and Bakhtar Master at Chor area, riverine area of Telipara. After offering morning namaz, Uncle Rahman sat down just being a large group of people who came from the eastern side, gherowed Uncle Rahman, Ainal Haq, Sophia Rahman, and Anwar Ali. Nur Islam did not tell me that hearing commotion, Anar, Sophia, and he went from home. If they are already there, they cannot forget that incident, lordship, that they were there, subsequently last people came. Because this is a serious incident, lordship. And they now they have developed their case. They are saying after hearing commotion, they went there. And then page 42 again, I am reading, lordship, PW10. I stated to police that I had been assaulted, but I did not state to them that Rahman and Sukur had been assaulted. The said two witnesses were, they said two houses were erected by Rahman and Sukur a week prior to the incident. It is not a fact that the said two houses are about 1 kilometer away from my house. The houses of Wali Master, Mojid Master, Mono Akhtar, Sofiul, Tahir Ali, and Sahir Ali are near my house. I did not notice whether any one of those people had gone to the PO or not. The PO was not visible as there were cultivation, rice jute, etc., plants, dhonsira, etc. So this is what I was placing for lordship, that the house is surrounded by that dhonsira plant. It is in the sketch map also, your lordship will find that aspect. I saw from a distance of 2 bigger land that the two houses had been gherowed. The two houses were gherowed separately. I did not able to recognize the people who had gherowed Sukur's house. Haidar, Joel, Shamsul Bari, Motiyar, Nur Bakhta, and some other people garnered the house of Rahman. Since some 35 people were there, I could not recognize the rest of the people. I do not know to which village the rest of the people belong. We went very close to the house. We forbade them. The walls of the house were made of thasses. As they came out of the house, they assaulted them on the threshold itself. No chair or table was there inside the house. This is also contradictory to other eyewitnesses. I saw bed inside the house of Rahman. While both of them were being assaulted, we were on the courtyard. Sukur fell down some 20-25 cubits east from the house. It is not a fact that I did not state before the police that hearing a hue and cry, I along with Anar, Ainal, Sophia and Anwar had gone there. The fight continued for 10-15 minutes after our arrival there. I do not deal in cattle. It is not a fact Anar, Anwar, Ainal and Sophia deal in cattle in Bangladesh. That this is Rahman used to provide us money in connection with this business. That we had dispute with the businessmen of Bangladesh several times, and that we had also dispute with the dacoits from Bangladesh on several occasions while we were taking cattle. Bangladesh is to the west of the PO. I do not know for how far it is. It is not a fact that Bangladesh is too far long away therefrom. It is not a fact that we, the above named people, Sukur and Rahman, had been sitting amidst the Kohuani area covered with Khan's grass since the previous night of the incident in connection with some illegal trade, and that some people from Bangladesh had come there and left the place that very night after assaulting us. It is not a fact that the incident took place at night. It is not a fact that the people I have named had not assaulted Rahman and Sukur. It is not a fact that my statement that Shamsul Bari and Nur Jamal had assaulted Sukur and that Joel Haq had assaulted me are also false. It is not a fact that there have been land dispute between the accused persons and us for 2-3 years, and that since we have not recognized the people who had assaulted us, I have adduced false evidence against the accused persons since we have disputes with them.
Is 409. His name is mentioned. He died. He is the one.
Actually, he died during trial. Yes.
PW 10 I have read. PW 11, Lordship. Page 45. Lord. Sukur Ali and Rahman Ali died about 6 years back. The incident took place at about 5:36 a.m. That day, that is on Saturday, I woke up and heard a commotion at a place about 8-10 bighas of land away from the southern side of my house where Sukur and Rahman had built houses. Rahman is my uncle. Sukur is my younger brother. Going there, I saw that the accused persons who are present in the dock today were harrowing the two houses belonging to Rahman and Sukur. They were rebuking Rahman and Sukur and asking them to come out of their houses. Then Rahman opened the door of his house. Amjad exhorted and the accused persons to attack, whereupon Haidar, Joel Haq and Irzat stabbed Rahman with Fala. Motiyar stabbed Rahman with Sulpi, a weapon similar to Fala. Nurbak stabbed Rahman with Fala. Shamsul Bari failed Sukur Ali by striking the latter in his legs with a lathi, and then Nur Jamal stabbed Sukur with Sulpi. When I went forward to save my younger brother, Nur Jamal broke a tooth of mine by hitting me with a stone. Shows the absence of a tooth in the left side of the upper jaw. Doctor removed the remaining portion of the broken tooth. Nurbak stabbed in the portion below the left arm with a sulpi. Bokhtar stabbed in the left side of the abdomen with a fala. Bokhtar died 3 years back. For my treatment, I stayed in Gazarikandi hospital for about 3 days, and thereafter I was in Dhubri Civil Hospital for about 5 days. Rahman died on the spot. Sukur Ali passed away while he was being brought to Dhubri. Sophia, Ainal, and Nur Islam also went along with me to the place of occurrence. My sister Kabi Khatun also went there. The complainant Usman Ali is my father. Land measuring 10 to 12 bighas alluvial from the river belong to us. Land measuring about 20-30 bighas alluviated there. At that time, perhaps 1,000 or 2,000 bighas of land alluviated in that region. We 7 Sarikan shareholders have lands there. 6 of our brothers, including me, are alive now. Tanuar, Anwar, and Sohidul stay with my father. 4 of the rest of our brothers, including me, one passed away, live separately. We, the said 4 brothers, have no share in the disputed land. My father had a share of about 2.5 bighas of land in the place of occurrence. My father's land is bounded in the north by Madhi land, in the south by Bokhtar Master's land, in the east by Sainuddin Master's land, and in the west by Samsul Bari's land. 2 houses were built over the land owned by Rahman Ali. The houses had been built 3 or 4 days before the incident. Rahman and Sukur were staying in these 2 newly built houses at night, keeping vigil at their cultivation. They were in those houses on the night before the day of occurrence. It is not a fact that I told police that at about 5 a.m., Rahman, Sukur, Ainal, Nur Islam, and I had been going to that house to do some household chores and cut Khan's grass, and that Uncle Rahman offered the morning namaz in that new house itself. So now this part, your Lordship will find page 67. I also said page 67, Lordship.
Yes.
PW 11, Anwar Ali told me that at about 5:30 a.m., Rahman, Sukur, Ainal, and Nur Islam had been going to that house to do household chores and cut threshing grass, and that Rahman offered the morning namaz in that house itself. So my point was that, Lordship, that if they are already there, after hearing hue and cry, they cannot go, Lordship. PW 11, Anwar Ali did not tell me that hearing commotion, he had gone out of his house. That did not tell me that hearing commotion, he had gone out of his house. That Joel Haq had stabbed Rahman with fala. That Irjat had stabbed Rahman with fala and sulpi. That Nur Bakhta had stabbed Rahman with fala. That Samsul Bari had failed Sukur by striking the latter with lathi in his legs. That Bokhtar had stabbed Anwar with sulpi, and that his father had gone to the PO. And these facts were also confronted to him at page 47, last part, to the witness. It is not a fact that I told police that hearing commotion, I had gone out of my house. It is also not a fact that I did not state before police that Joel Haq and Irjat had stabbed Rahman with fala, that Motiar had stabbed Rahman with sulpi, that Nur Bakhta had stabbed Rahman with fala, and that Samsul Bari had failed Sukur by striking the latter with lathi in the legs. Nur Bakhta and Bakhtar are 2 different persons. It is not a fact that Nur Bakhtar did not stab me. It is not a fact that I did not tell police that Bakhtar had stabbed me in the abdomen. Page 48, I am continuing, Lordship.
Yes.
Cross, since 16 accused out the house, the campus of both the houses were out at that time. So he is exactly saying 16 persons. 16 accused out the house. The campus of both the houses were out at the same time. Hearing commotion, we went there empty-handed. We stopped at a distance of about 10-15 cubits. As soon as Rahman opened the door, Haidar struck Rahman with Fala, and then Rahman fell down on the ground inside the house. The accused persons went inside the house and assaulted Rahman. 6 accused persons entered Rahman's house. 2 accused persons, namely Samsul Bari and Nur Jamal, entered Sukur's house. They entered the house as soon as the door was opened. The assault was made inside the house itself. We were standing at a place of northeast of Rahman's house. The 2 houses are 13-14 cubits wide. There were Kohuabon and Dhansira to the south and the east of the house respectively. There was jute cultivation to the east. Rahman's house is facing the north, whereas Sukur's house is facing south. We could not go near as the assault was being made at that time. The assault continued till around 5:20 to 6 o'clock. During that period of time, I did not see any other villager there. My father reached the PO about 5 minutes after I had reached there. So now, he is son of Usman Ali. Other
Yes,
witnesses?
so PW 9 has said that they all accompanied.
Yes, they all accompany.
So there is a little discrepancy here.
Discrepancies.
But this much is sure that all of them went to the place.
But at what time they went there, that is my later, Sairuddin, Nazir Muhammad and Mukhtar went there and brought us back from there. After Rahman had died and when Sukur was lying there, the said persons reached there. Then they brought us back. And PW10 said, Lordship, that they fled away. And here he said, when Sukur Ali was lying, the said persons reached there, then they brought us back. It is not a fact that the statement that my father and the aforementioned persons had gone to the place of occurrence is false, and I did not state the same before the police. But I stated before the police that when Rahman Ali had fallen down, Nur Jamal had hit me with a stone, as a result of which I had fallen down, and that Sukur had tried to lift me up. It is not a fact that I do smuggling along with some Bangladeshi persons and that Sukur, Rahman and our brothers also involved in smuggling. It is not a fact that Fazal, the dacoit, is also my partner. It is not a fact that some Bangladeshi dacoits threatened us a week before the incident that in order to settle the matter amicably, we went to that house in that night, that the Bangladeshi persons had assaulted us before we reached the house, that when I got hit with something hurled towards me, I ran away and I saw nothing else. It is not a fact that incident took place after 4:30 at night. It is not a fact that many persons of our locality knew that we had been thus threatened. It is not a fact that I have been adduced false evidence against the accused, as it was a land dispute. It is not a fact that the statements that the accused persons had assaulted Rahman, Sukur and me are false. Now, PW12, Lordship may see, page 50.
Daughter of Rahman.
Daughter of Rahman. She went to the place of occurrence at 6 a.m. and she found her father died, Lordship, already died. Rahman Ali. And she further said, Lordship, in page 51. Only my father was there inside the house. There was no other person. Seeing my father, I lost senses. Thereafter, many people gathered there
Oh, she went after the occurrence.
after the event.
Hmm.
But when her father was lying there, no one was there, that part, at 6 a.m. Because if those eyewitnesses are there, they ought to have been there, Lordship, nearby the dead body, Lordship. Because timing is almost same. They are also saying 6 a.m.
No, but he says na, that left the place.
No, I'm speaking about those witnesses, Lord, presence of those
That's
witnesses.
right. PW9 has said that. PW9 or 10 has said that.
They fled away and they again came after
That's
the
right.
accused persons left. Even they are
They
trying
fled
to,
away out of fear. That's what he said.
but they are projecting that they saw that they are running away. The accused persons are running away.
PW9, PW10 has said that. Not 10, 9. Said the person who had accompanied me also fled.
Right.
All of us returned there again after the accused had left the place.
Okay.
Yes. What do you want to show from PW13?
PW13, there is only one thing, Lordship. Page 53, examination in chief.
Hmm.
Last 3 lines, Lordship. Last 4 lines. I saw elder brother Rahman lying dead near the door of the house. We were carrying Sukur to hospital, but he did not died on the way. From the conversation that I heard, that when the stones were being hurled, I could learn that Izzat Ali, he is not before your lordship. Fajr Ali, he is not before your lordship. Anwar Ali, he is not before your lordship. Mansoor Ali and Amjad Ali. Amjad Ali already died, shouting assault, assault. So that the person who was in, before the death, he only named this person. And now I'm taking to your taking your lordships to page 54. Evidence of PW13.
Hmm.
Last paragraph, Lordship may kindly see. When one of Anwar's teeth got broken, he started running towards the old house. You also saw from the place where we were hiding, Sukur holding his abdomen and running towards the old house. Taking along Sukur, I entered the old house. Later, I took him to Gazarigandhi hospital. So immediately he was taken to hospital. But if your lordship see the inquest report, just I'm taking your lordship to inquest report.
Page number?
Just 436, lordship. First one is 446. And regarding Sukur, your lordship will be 441. 441, lordship.
441.
441, lordship.
Yes.
Incident, lordship, is of 11/10/1997 at 6:07 a.m. And lordship may see 441 inquest report. The place Pathalbari bus stand. Date 12/10/97. Time 8:10 a.m. On the next day. And no dying declaration was recorded during that 11th, Lordship. And
Incident
whereas
occurred on 11:10.
11:10 morning time,
And after 20, the body was lying there for 24 hours.
yes, in Kothalbari bus stand, not in the place of occurrence. Therefore, I have shown the place of occurrence. Lord. Because they are saying that they were, when they were trying to take him to hospital, on the way to hospital, he died.
So
If
this
on-
is inquest on body of Sukur.
Sukur. And PW 13 said, Lordship, as I have placed your Lordship, that he was taking the victim when he, to hospital and then he died. But in page 443, the witnesses to the inquest, he is
So
not.
what is wrong with this? Sukur was taken to the hospital.
Lordship,
There he died on the way.
yeah, he died.
So maybe on return, the body was found in the bus stand.
No, the witnesses, all the witnesses said, Lordship, when he was taken to hospital, he died. On his way to hospital, he died.
Correct. But they didn't say we gave up taking him home to the hospital. He could have been brought there to the hospital also.
No, at that time, he was alive
What you are saying is
Lordship.
that he died on the way to hospital.
on the way to.
Therefore, they brought him back home. That's what you're suggesting.
No,
Therefore, the inquest could not have happened in the bus stand. That you
no, my
have to
case,
complete your formulation.
Lordship, my case is that the incident occurred on 11th, Lordship, at morning 6 a.m.
Correct.
They immediately took him to hospital.
Yes.
In between, he died, Lordship.
Yes.
So on the way, because he did not reach the hospital, Lordship.
Hmm.
So immediately they informed the police. The police came and police came on 12/10/97 at 8:10 a.m. But in the prosecution failed to show that he was not alive at that point of time during that period. Because the witnesses said when he was, the injured person was taken from the place of occurrence, he was alive. And how
So
he,
you are saying the inquest was done when the victim was alive?
no, after death. After death, that is, Lordship, after 24 hours.
Actually, we'll see. They will address.
Lordship.
This is inquest was conducted by PW.
By Lordship, by the
Was it the IO? No.
Apurva Kumar Sharma SI. He is PW 17 IO.
So
And
any
in
questions put to him during his examination regarding the inquest?
regarding the inquest, it is not.
Has the inquest been assailed during his?
No, I am not assailing the inquest, but my only submission to your Lordship is that inquest was done after his death. And he was alive during that daytime, and his dying declaration was not recorded by the prosecution, Lordship. And how his body came to that Lordship bus stand, that is also not there.
The oral dying declaration is there. No, PW 13 has mentioned about it. Yes, the answer is there in page 64. Mr. Ahmed, please don't mislead us. Whatever is there, no? Otherwise, you are just, you can't get anything by confusing us. All these things are clearly mentioned in page 64.
I'm sorry, Lordship, probably I could not place my case properly. This is what I was submitting, Lordship. That during the daytime, he was, Lordship, alive. And the IO received the information subsequently, Lordship. And accordingly, he made the inquest in the next day, Lordship, at 8 a.m. So during that period, Lordship, the prosecution did not even recorded the dying declaration of the deceased. Rahman, that was my submission because he died subsequently. He did not die immediately, Lordship.
All right, yes.
And now your Lordship may kindly turn to page 57 is the evidence of the doctor who conducted postmortem. And regarding Rahman Ali, that your Lordship has already seen that regarding inquest report. And in page 60, Lordship may kindly see. Sorry, Lordship, page 58, Lordship. Page 58, this is regarding Sukur. Swelling of right side of cheek and right side of neck. The dissection gaseous material came out. Emphysema of neck noted. So regarding this, Lordship, just I'm pausing, Lordship, regarding that injury number 1. This injury, Lordship, may now kindly for a moment, page 60. Last paragraph, Lordship, in respect of this is Sukur Ali. In injury number 1, is the epithemia may be caused by strangulation by neck. Injury number 5, semen-like discharge substance found may be result of strangulation on neck. Half-digested food might have been taken 3-4 hours before death. So regarding that strangulation, nothing is there on record, Lord, although they projected themselves as eyewitnesses. A penetrating wound with wound of entry is present mid axillary line in 5th intercostal space. Blood stain discharge of gas coming out of wound. Wound of traces up to 2 centimeter depth of lung tissues, injuring plea, lung tissues and intercostal vessels. Blood clot is present in the lung with collapse. Swelling of right testis is present with blood
No,
clots.
what is your submission here? What are you saying? Strangulation, there's no medical evidence. Is that what you're saying?
No, strangulation, doctor opined that probably he was strangulated at some point of time during a altercation. But that is not described by any of the witnesses, Lordship, that he was strangulated. Because of that, Lordship will find that injury number 5, semen-like discharge substance may be found result of strangulation on neck. The opinion part, page 60. They are describing each and every injury caused by the accused persons, but regarding this, they have not said anything.
So the conclusion is they are not eyewitnesses.
Along with the other contradictions which I have placed before your Lordship. And second,
If that submission is accepted by the court, then it's one thing. But if it is not,
Lordship,
then that's the end of the matter. That you agree?
Lordship. Then page 59, your Lordship will find that Rahman Ali's report, Lordship. Here your Lordship will find 4 numbers of injuries are there, all sharp cutting wound. And witnesses stated about pointed weapons. None of them depose about dao or sword or knife, nothing. Only pointed weapon and no punctured injury is there.
There are 4 number of injuries.
Yes, and witnesses say 7 numbers.
Not witnesses. One of the witnesses said 7.
And the other witness also said, Lordship, that I have PW 8.
Yes.
And last, Lordship submission, Lordship, page 68, Lordship. Just regarding PW 13, because PW 10 also said about that he also accompanied them, Lordship. PW 13 also accompanied them. PW 13, so second paragraph I'm reading, Lordship. PW 13, Sofiur Rahman did not tell me that hearing commotion from the house, he went to the PO along with his younger and elder brothers. Because PW 9 said, I accompanied by Anwar, Sophia, Anwar that PW 11, Sophia PW 13 that I have now placed before your Lordship. Tohidur Islam, he is not examined. Nur Islam PW 10 and my father PW 4. So their statements during investigation, they did not say that they, on hearing hue and cry, they went there. During investigation, they said that they were already there. So this is my submission before your Lordship, that from the contradiction which I have placed before your Lordship, that they were not present, whether they were present at the place of occurrence or after hearing the hue and cry, they went there. That is not clear from the evidence, Lordship. They have developed their case from investigation stage and while deposing before the court. And they all are related witness, Lordship. Therefore, their evidence has to be scrutinized carefully. And if my submission is that on careful scrutiny, Lordship, their evidence is not found to be wholly reliable. And the second thing, Lordship, that they have stated about all the witnesses, Lordship, stated about pointed weapons. And if pointed weapons are there, that cut injury cannot be, Lordship, there, Lordship. And the prosecution also failed to brought on record that injuries sustained by the deceased were caused by, Lordship, that pointed weapons. And time of death also there, it is not mentioned in the postmortem.
Whose time of death?
Deceased, Lordship. Deceased, that they gave an approximate time that died about 4 or 5 hours or 6, 12 hours, the approximate time of death. Considering the rigor mortis and other things.
But
because
exact time, how will they give? It's
not
given,
exact time, Lordship, approximate time.
It is not given.
Not given, Lordship. Because defense case was that at night time, some records came and killed them, Lord. And they did not witness subsequently that the eyewitnesses, injured eyewitnesses, Lordship. They said, Lordship, during investigation that they were present there. But during trial, it is not there. And although they are treated as eyewitness, just now I'm taking to PW1, Lordship. PW1 page, your Lordship will find page 13. Here, Lordship, it is written as Anwar Malik. So subject to correction, what my learned friend says, witness, one, among Anwar Malik as a Anwar Malik, that I have not found in his evidence, Lordship. Anwar Malik. Father, Anwar Malik.
PW1 is Atwar Rahman.
Atwar Rahman. We examined the witness down below, your Lordship will find. I examined Anwar Malik. So Anwar Malik. That Anwar Malik, Lordship, I have not found. Anwar Hussain, Anwar Malik. And Lordship, then second year, Lordship will find page 14, last part, Ainal Haq. He already said that, Lordship, he sustained injury after when he left, Lordship.
Yes.
And from his evidence, just two things I am pointing out, Lordship. Page 13, your Lordship will find on the same day when the incident took place, these injured were taken to hospital at 7:15 a.m. But your Lordship has seen that Rahman Ali was was not immediately taken to hospital. Lord.
Rahman Ali died
Died.
instantaneously.
His inquest is subsequently because immediate after during FIR was lodged at Lordship, just for time, Lordship. FIR was lodged at 2 p.m. Till then, FIR says, Lordship, that Sukur Ali grievous injury. But till 2 p.m., he did not die. Lord. Till 2 p.m. Because FIR was lodged on at 2 p.m. Page 1, your Lordship will find information received 11:10:97 2 p.m. and there just above line one line above line you will find occurrence 11:10:97 6:07 a.m.
The FIR
And-
says instantaneous death.
No, instantaneous death of Rahman Ali and Sukur Ali grievous injury. Sukur died subsequently.
That's correct.
Sukur died subsequently. His dying declaration
So
was
why are you saying Rahman Ali was alive till 2
I'm
p.m.?
sorry, that name I got confused. Sukur Ali.
Don't confuse us. If you're not sure, then don't make a submission.
Okay.
Because we take you seriously.
Gotcha.
We will stop taking you seriously.
I'm sorry.
Every submission you make, we have to verify. You don't make wrong submissions.
That Sukur Ali died subsequently.
Of course, there is evidence to show that he was taken to the hospital and the way he died, but
Gotcha.
they still continued, brought him to the hospital. Thereafter, on his return, the bus stand next morning, the inspector got the information. He came and conducted the inquest. There is nothing you can confuse the court on that.
No, Lordship, my only submission is that, Lordship, that injured were taken at 7:15
Do bring out contradictions,
Lordship.
but don't try to confuse the court. That's not going to take you anywhere. All we'll do is, before writing a judgment, we are going to verify everything.
Lordship.
Creating confusion is not going to work out in the high court level.
I'm just
Please
facing the
don't
fact
try
of
that.
the-
No, if you make submissions which are not correct,
Lordship.
then what happens is we'll be required to verify every submission you made. And that's not a good sign. In your anxiety to win a case for your client,
No,
don't
Lordship,
forget
just only
that
the name I
you are
got
an
confused,
officer of
Lordship.
the court.
Lordship. The facts, Lordship, I have placed.
Oh, you made a complete submission that he did not
Absolutely.
die instantaneously. He was alive till 2 o'clock.
Lordship.
He was at 2. Just now you made this submission.
Yes.
That was in reference to Rahman Ali,
No,
not Sukur Ali.
that Lordship, I have mentioned about Rahman Ali instead of Sukur Ali, Lordship. But
All
that
right, all
fact
right.
is
Please,
correct.
please continue.
Page 5, Lordship, may I kindly see? Page 5,
Please.
page 5 of the FIR. Lordship.
Yes.
That attack causing Rahman Ali's instantaneous death and my son Sukur Ali's grievous injury.
Hmm.
And down below, your Lordship will find name of injured person Sukur Ali. So he was alive at that point of time.
Correct. He was alive.
He was alive. So there is no dying declaration that only I'm on that.
So the police was not informed.
No,
immediately.
FIR was there. FIR was there at 2 p.m. And he, in the IO, in his evidence has said, Lordship, that subsequently he was informed that this person died.
Dying declaration, they are not relying on any dying declaration.
No, that
There was
also-
no dying declaration doesn't mean it should lead to acquittal of accused. Dying declaration may or may not have been recorded. We are only on the question whether the evidence on record is sufficient to sustain conviction or not. What has not been done, this has not been done. They have not given him saline. They have not. We are not getting into all these things. Dying declaration was not recorded. Yes, was not recorded. If it was recorded and your clients were implicated, that would have been more corroboration. It was not done.
But at least the truth would have come out. Lord.
All right, all right. Yes.
These are my submissions, that contradictions and that regarding medical and ocular evidence and contradictions between witnesses and the time of death, Lordship, that he was alive for hours, Lordship, but his dying declaration was not recorded. Or neither any of the witnesses or none of the witnesses said that he has stated anything about the accused person.
And what do you have to say on this decision, minor discrepancies which do
No,
not
here,
go-
Lordship,
Which is the paragraph in this judgment?
Abdul Kadir. Lordship is para 49.
Yes.
Insofar as the omissions and discrepancies in the testimony of the prosecution witnesses are concerned, law is well settled by means of long line of judicial pronouncements that minor contradictions and discrepancies in the testimony of witnesses would not have a fatal bearing in the prosecution case unless the same goes into the root of the matter. In the case, certain case laws have been referred, Your Lordship. Then para 51, in the present case, we have noticed that there are some omissions such as failure on the part of PWs 4 and 9 to state before the police that arrived at the place of occurrence in a motorcycle and that the PW1 failed to state that as
All right.
so.
So you, in your reply, you address, you make your submissions after the lunch recess, Huh?
Can it be day after?
day after. All right, you take down, Mr. A. Ahmed, learned counsel for the appellants has made his submissions. Ms. B. Bhuya, learned APPS, hearing for the state. 6 posting of the appeal for further hearing again on if day after tomorrow. Also, in view of the above, that this appeal be listed further hearing on so and so as a fixed. Both of you, please make a note.
Lordship.
You make a note of the witnesses.
I have already made, but I will correct it and I will furnish.
Right. And you also tell us who has died, who has faced trial, who's died during trial, etc.
Lordship.
And where is the chain?
Is,
Okay.
yes.
Tell us that. Please read this judgment
Lord.
and you have to address the court on that.
Right.
There are minor contradictions, but that kind of contradiction will be there in every appeal, in every criminal trial. That by itself is not enough. There has to be something fundamental which raises a doubt that these witnesses were all telling lies. They were not speaking the truth. The evidence is not there.
No.
Otherwise, difficult.
I will address it after.
Right, that also for the time being. You're right, none appears for the applicant in this case, even on the second call made during the course of the day. Anybody for the other side? Considering the nature of issue involved in this proceeding and for ends of justice, we are, however, of the opinion that the applicant must be given one more opportunity to press this IA. As such, let this IA be listed again on Next 20th of November. Next item.
My lord, I am for the respondent. Pass over.
Time being, time being.
Timing.
Pass over the
Time being.
time being.
Right, we'll have it at 2.
Fine.
What about item 9, 10, 11?
I'm appearing and item number 9. And 9 and 10 I am appearing.
Ready for hearing?
No, my client is in jail, Lordship. He is in custody. There was observation that if hearing is not taking place today, Lordship, then my IA will be considered, Lordship.
When the matter is called,
He was there in item number 88 in court number 4. It is still going on, my lord.
My lord, I have no objection because I am the respondent.
Hmm.
So they are the appellant. They want to set aside the,
who is your senior?
Mr. K.R. Padgit.
We'll adjourn it for 2 weeks then. Uh, When this matter is called up for final hearing, the learned counsel for the appellant has sought adjournment on the ground that the arguing counsel, Mr. K.R. Padgiri, is on legs in another court. Mr. K. Bhattacharya, learned counsel for the respondent, present and does not have any objection if the prayer for adjournment is allowed. In view of the above, adjournment of hearing of this appeal stands and the hearing of this appeal stands adjourned for 2 weeks. Is to list the matter accordingly.
oblige you.
Obliged.
Item 9, 10, and 11.
Dear Lordship, I am for appellant Ibrahim Ali and Ayub Khan. That is item number 9 and 10. Here
The
my
appeal has been
IA,
listed for final hearing.
my IA is still pending, Lordship. That IA
What is the IA number?
IA number 473. Ibrahim, only for Ibrahim. Others, Lordship, that Ayub Khan and Rafiqul Islam, they were convicted for under section 379, 411 for 3 years, and they are already on bail, Lord. On previous bail.
They are the appellants in which item?
Item number 10 and 11, Lordship.
And for 11, Rashid, do you have a has been convicted of that? Yes,
They are out on bail.
yes.
Yes.
All right, now let's just, you wanted adjournment of the hearing, is it?
Yes.
And
The kids are calling.
paper book is not ready.
The book is ready, but probably it is not furnished to them, Lord.
Achha. Now, this applicant Ibrahim Ali, he is
Yes.
convicted under which section?
302 on the basis of circumstantial evidence, and that circumstance was taken from the case diary without proving that. Because the prime accused Molodas, who took the deceased, who hired the vehicle of the deceased, confessed that he took the deceased and subsequently he killed. And this present applicant Ibrahim Ali, along with few others, were along with the Molodas, Lordship. In police custody, while he was in police custody, he confessed that, and that confession was taken. Paragraph 47 of the judgment, your Lordship will find. In the paper book, your Lordship will find 115.
Just a moment.
Sure.
Let us see what is there in the Ejahar.
Rajahar, your Lordship will find at page 4.
All right, now The dead body was recovered later on.
recovered at the instance of Molodas.
Now, what is the basis of conviction of the applicant here?
Basis of conviction is that, Lordship, the witnesses said when Molodas was apprehended by the public, thereafter, after apprehending, he was handed over to police. In police custody, he said my name, that I was accompanying him, only that much. And even he was in police custody, Molodas, and Molodas' statement is not exhibited that living apart that side, Lordship. And his statement, he stated while he was in police custody, Lordship.
Molodas.
Molodas. And
And
paragraph
Molodas led to the discovery of the body.
body. And he admitted before PW1, before going to police custody, that he hired the vehicle, he killed the deceased. PW1, your Lordship will find at page 8.
So what, Molodas is an approver here? No, he's
No,
an
he died. He subsequently died. He was one of the accused, but probably during investigation, he died, Lord. He was the main accused.
Is that so, Ms. Bhuya?
But I have gathered Molodas is expired, and during the commission of the crime, Ibrahim was also present. They have stolen the vehicle and thereafter killed the dead body.
That's something
Yes.
else. What is the material to convict him?
To convict him, your lordship, because the lordship before PW1 to from the paper which I have gathered now, that he has confessed before the PWs that the accused person was very much present, your lordship, at the time.
Who has confessed? Molodas.
Yes,
So
lordship, may kindly have a look at.
extrajudicial confession.
Yes, my lord. Not only before one witnesses, but 2-3 witnesses he confessed. Subsequently, the car was sold to somebody else from Arunachal Pradesh. Before the dead body was thrown, after the dead body was thrown out.
So extrajudicial confession is the only basis.
Can be, and there, I don't know whether disclosure statement is there or not, but here Moloda showed the place where the dead body was dumped, your lordship. Subsequently, it is
That's correct.
recovered.
That's
Yes,
But we are now only on the question of bail.
lordship.
Isn't
And
that-
he, lordship, one more circumstances that this Ibrahim, he sold out the vehicle to somebody else. He's the one. Before PW3 also page 17. Kasem Ali, Ibir Ali, Sagar Das and a woman were with him. And when the victim was assaulted, accused Ibir Ibrahim was in the car. And lordship, while taking the vehicle away, the entire party stayed in the house of Ibrahim.
Where is the operative part of the judgment? of the crime
Lordship,
court?
it starts from paragraph 30 that your Lordship will find page 109.
Where is the operative part?
Para 46 onwards, so page 115.
From paragraph 45 also your Lordship may kindly see. Because prior to that, other witnesses were discussed. On page 4.
And para 47, your lordship. The involvement of the present applicant.
Where is the part of the order where the applicant has been found guilty under
Lordship, para 46 onwards, page 115.
para 46?
Yes, my lord.
Only page 46.
No, so it starts from paragraph 30, Lordship. And 32, your
His
lordship.
conviction is with the assistance of section 34.
Yes,
No,
30
no.
to 34, conviction.
On the
302.
302.
Okay.
302 with the
302.
assistance of 34.
No, 34 is not there. Lord.
Then
Yes, 34
Yes,
is there. 34
34.
is there. Lordship.
which part is it? Can you please show? I have not read this paper book before. Where is 34 entangled? Where is 34 brought in? Where is the finding pertinent to 34?
34.
Common intent, there is
Lordship.
finding.
Para 56, your lordship again.
Miss Bhuya,
My lord.
you understand what I am hinting at? Serious problem here.
Intra matter may be hard, your lordship.
Why? We'll look into something else. Let him be on bail for some time. What is there in this case? How will you sustain this conviction? Let's get into a fundamental area so that someday you can at least argue if you get a chance. The best case of the prosecution is he was one of the team members along with Mrs. Malodas that kidnapped the victim responsible for his murder. That's the best case of the. Malodas died during investigation. If you want to convict the applicant here at 302, there has to be a finding on the basis of evidence on record that he acted with a common intention.
Lordship,
Where is
common
the finding? Where is the evidence?
evidence regarding common intention is that they hired a vehicle, lordship, then took the vehicle in order to sold it out and their lordship and on
There
the
you
way.
say,
Yes.
the common intention is to steal the vehicle and sell it.
And
Murder him.
on the way, lordship, they might
That's
be.
where
I have to
the-
go through the entire records. I've just read the paper book, your lordship.
When I said I didn't read the paper book, I was not telling you the whole truth. I wanted to just find out much.
But lordship, in fact,
See,
I have
that
not gone to
problem
the
is
paper
there
book.
in this case. All right, we'll take it up tomorrow for orders.
Tomorrow.
Just go through two things you please see. Have your satisfaction. Number one is that extrajudicial confession, that too part of which made in police custody, obviously cannot be.
No, it was not. Before he was handed over to police, before he shown the
Let's
dead
take
body,
an
it was,
extrajudicial
yes,
confession.
yes.
That is the only ground. Second thing is, even if assuming that The, this accused Manodas merely said that he was along with us. He was not implicated of any overt or covert role, but let's assume that it was done. Even then, to convict him under 302 with the assistance of 34, the learned judge will have to record findings of common intention of murder, not of stealing the vehicle. And that observation, that finding has to be based on cogent materials on record. So if it is there, we'll not grant him bail. If it is not, he will be released on bail.
Lordship,
We'll hear the matter in due course
day after tomorrow then,
after tomorrow.
Thursday. Will not take much time,
Right.
perhaps.
I heard Mr. In the I hear you write the order. But Mr. A. Amil and counsel, the applicant also had Ms. Bhuya learned PPSR appearing for the state. On the request of Ms. Bhuya, this matter is directed to be listed again for orders as a fixed item, along with item numbers 10 and 11. Mr. B. Chaudhary, learned counsel for present, appellant in the other case, in item 11 is present, along with Mr. Who's there in item 10 for the
I'm
appellant?
okay.
You are there in item
I-
10 also. Along with Mr. A. Ahmed, learned counsel appearing for the appellants in item 10. In the meantime, a copy of the paper book be furnished to Mr. B. Chaudhary, learned counsel for the appellant in item 11. In the meantime, I will register to furnish a copy of the paper. Is there any part? So we'll not adjourn these cases on the next. And the other matter, the consideration will be on this short point. First of all, what is the evidence? It is extrajudicial evidence, extrajudicial confession. That, as you know, is a big piece of evidence. Secondly, even assuming that that is cogent and reliable evidence, even then there has to be conviction on the basis of finding of common intent under 34. There are judgments even of this court that finding has to be recorded. Merely jumping into conclusion of 34, that will not do. Please see that. You also come up with the judgment.
Lordship, I will place before.
Yeah, there are judgments authored by me
Lordship.
and there are Supreme Court judgments also. So Thursday, our plate is full. Yes.